from the firm.
Excuse me. Am I being fired?
Let me put it this way, Andy. Your place in the future of this firm is no longer secure.
In a case that is eerily reminiscent of a recent Hollywood movie, Scott Doe's former employers said his work just wasn't up to their demanding standards, so they let him go.
Did you know at any time prior to his leaving the firm that he was HIV positive?
Absolutely not, sir.
There's a stigma attached of people finding out that you have a lawyer that works with you that has AIDS.
Scott Doe, which is not his real name, says his career with the firm of Kohn, Nast & Graff got off to a great start. He worked long hours, won nothing but praise, and twice was given a generous bonus.
I thought that it was the way the firm was telling me that I was doing a good job. It was a confirmation that they wanted me to keep it up, that they liked what I was doing. They gave.
Then, after just 18 months at the firm, Scott Doe learned he has the virus that causes AIDS.
That the antigen for the HIV virus was in my body, and that I had the AIDS virus.
Although he tried to hide his condition, Scott Doe claims the firm quickly figured out something was wrong and almost as quickly fired him.
I'd come in the morning and my boxes were all packed up, everything in my office was cleared off. And Harold Kohn had asked for my building pass and my key, and he said, if you don't turn it over, I'll have to get security.
Suddenly, Scott Doe's life began to look a bit too much like the hit movie Philadelphia.
Sir, did you get the idea for this lawsuit from that movie?
No, sir.
In the film, actor Tom Hanks plays a hotshot young attorney who is forced out when his law firm discovers he has AIDS. In the real-life case of Scott Doe, the lawyers of Kohn, Nast & Graff say they never knew the young lawyer has the AIDS virus.
I was extremely annoyed at both the quality of the work that he had given me, as well as the amount of effort he had put forward in terms of time.
Devastated by the loss of both his health and his career, Scott Doe took the firm to court, charging discrimination.
I think Stephen Asher, my supervisor, found out about my HIV. Number one, he may have been scared, but I think what was more the case was the fact that he did not want to have an associate associated with him that down the road may have AIDS.
Scott Doe used a new civil rights law, the Americans with Disabilities Act. The law is clear. It protects disabled workers from discrimination by their employers. But Scott Doe wanted the answer to a question that could affect thousands of Americans. Does simply carrying the AIDS virus before any symptoms of AIDS appear mean that a person is disabled? In the next hour, the jury must decide whether a nationally known law firm broke the law by discriminating against one of its own.
We're about to proceed with the opening statements of counsel.
In federal court in Philadelphia, Scott Doe's lawyer, Alan Epstein, tells the jury it is about to hear a tragedy born among people who are supposed to protect the law, not break it.
It is a tragedy that is woven of a web of deceit from lawyers who are sworn to come to this courtroom and defend the truth. It is a tragedy that is born and arises from two deadly viruses. The first deadly virus is one called the human immunodeficiency virus, or HIV. It is a virus that invaded the body of a 28-year-old promising lawyer with the world in front of him. The second deadly virus is the virus of invidious discrimination. That virus invaded an entire law firm.
Defense lawyer William O'Brien tells the jury that Scott Doe is a disgruntled former employee who sought revenge for his own failings.
When you hear the evidence, you'll know that what he said was, I'm going to ruin this firm. I'm going to hurt Steve Asher. I'm going to hurt Harold Kohn. Who are they to do this? You'll hear that he blamed his failings on other people. Responsibility means that you don't do that. You accept responsibility. you'll hear the evidence that he began getting confidential information in Mr. Asher's desk. Stuff that no one knew. He got material about what everybody was paid. He put materials together and tried to sell while he's working at the firm on firm letterhead to ABC and NBC and CBS. This is an exclusive right to a bombshell. You'll hear the evidence that will convince you that he knew that he had no future. And when he knew that his contract wouldn't be renewed, he started on this other plan.
At issue here, the credibility of lawyers. Was Scott Doe the victim of discrimination, or did he plan to ruin the firm and profit from his own actions?
Stay tuned for more of Trials.
The reason this firm fired me in the way they did was because they thought that I would not take any action against them. Because for me to bring a lawsuit would have risked exposure of who I was, and it would have forever ruined my legal career.
Scott Doe worked hard and won scholarships to college and law school. Now without a job, he couldn't afford to pay a lawyer up front, and few were willing to take on the high-powered Kohn firm. Then, just before trial, he found Alan Epstein.
This time I'd like to call Ann Caldwell to the stand.
Epstein begins the case by calling a series of attorneys who worked with Scott Doe before he was hired by Kohn, Nast, and Graff.
I thought Scott's legal writing was outstanding, and I thought he was produced a legal product beyond his level. I was quite happy with his work. I thought that Scott's work was very good. It was of very high quality. I thought that he was a very good writer and that he had excellent research and analytical skills.
He really loved the law. I mean, and I don't mean to over-dramatize it, but Scott is somebody who just threw himself into projects.
But none of these witnesses can answer a crucial question asked by defense lawyer William O'Brien.
Do you have any independent knowledge of the work that he did at the Kohn Nast firm?
I do not.
Have you ever had a chance to talk to Diane Nast about the work that he did for her?
I have not spoken to Diane Nast.
Have you ever had a chance to talk to Mr. Stephen Asher about the work that he did for him?
No, I haven't.
So you really have no idea as to the kinds of work that he did and the quality of the work that he did at Kohn Nast, do you, ma'am?
I don't.
I'd like to call the next witness to the stand. I'd like to call the plaintiff, Scott Doe.
Epstein gambles that jurors will overcome any fear of AIDS once they meet Scott Doe and puts the plaintiff on the stand early in the case.
You swear testimony you should give to the court and the jury will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Scott Doe tells of his struggle to become an attorney. At age 27, he beat out more than 100 applicants for a job at the prestigious firm of Kohn, Nast, and Graff. From the start, he says, he won praise from his exacting boss, Stephen Asher.
During the fall of 1991, I can remember we worked together on I believe it was a SIR reply brief from the wallpaper case till 11 o'clock one night. And he had asked me whether I could meet him for breakfast the following morning at 8 o'clock. We met in the cafeteria at the ARA Tower, and he proceeded to tell me that he thought that I had what he said could make it as a shareholder in the firm. So there were 3 criteria that, and he said the first one was that he thought I did A-quality work. The second one, he said, is that I had a good appearance. And the third one, he said that he thought I was diligent, and he wanted me to keep the work up, and he encouraged me to do it.
10 months later, Scott Doe became ill, and his doctor referred him to an AIDS specialist. A few days later, he got the terrible news.
That the antigen for the HIV virus was in my body, and that I had the AIDS virus, and I was upset.
Epstein asked Scott Doe to read the living will he wrote just days after learning he is HIV positive.
And what is plaintiff's exhibit number 45?
The first page is a cover letter to Dr. Michael Brathman and to Dr. William Lord. The second page is my living will declaration. explaining in the event of my death how I should, well, in the event that I become permanently incompetent or have a terminal condition, how I wish to have my life extinguished. I release you or any agent in any hospital in which you treat me of any potential liability for withholding or withdrawing life-sustaining treatment. It serves only to prolong the process of my dying. Thank you for your attention to this matter. Very truly yours.
Do you want to take a moment?
No, fine.
Two firm employees helped Scott Doe prepare the living will. One reason, he says, his condition was no secret. Another was his appearance. He explains that he was so depressed, he lost weight and developed a severe rash, symptoms that mimic AIDS.
You can see my skin and bones. I was like really thin and gone.
In December, a letter from an AIDS specialist, Dr. John G. Bartlett, ended up in plain view on Scott Doe's desk. But the plaintiff says he didn't think much about it, despite a sudden change in Stephen Asher.
Our offices were 2 offices apart, and he wouldn't come by, say hello, he wouldn't talk to me, he avoided me.
Still, Scott Doe says he continued to get positive feedback from Stephen Asher.
This is a letter on Mr. Asher's stationery to me. It was laying on my desk, and it says, good job on the lumbar motion. I sent it as is.
But 6 weeks later, on January 13th, 1993, Stephen Asher called Scott Doe into his office.
I sat down on a chair in front of his desk, and he just leaned over and he told me, I was told to tell you your status at the firm. You do not meet my expectations. I told Mr. Kohn, he said, I told Harold that in 2 or 3 years, you would not develop into the kind of attorney that could do work at this firm. Therefore, you should leave and find a job as soon as possible.
Scott Doe was brokenhearted, but he left Asher's office vowing to change their minds.
I thought to myself, I love my job. I love the kind of work I did. I wanted to work as hard as possible to show them, to show Mr. Asher, to show Harold and the other people at the firm how good of an associate and how good of a lawyer I could be. And that even though that my life expectancy may be shortened, I'm going to work twice as hard to be as good as I can be.
Scott Doe's contract said he could stay with the firm through 1993, another 11 and a half months. But the young lawyer felt he was being pushed out.
The firm took away my secretary. They assigned her to a partner on the other side of the firm. I had a computer that was in my office area, and that was removed and given to another lawyer.
Scott Doe says he was treated so badly that he complained to senior attorney Diane Nast.
Did you follow up your conversation with Diane Nast and your complaints to Diane Nast about Mr. Asher's behavior with a memorandum?
Yes, I did. He has treated me as if I am a leper or a carrier of the plague. In light of this inexcusable and intolerable situation, I would appreciate it if you and Miles would hereafter coordinate my work assignments for the duration of my association with this firm. Thank you for your cooperation in this matter.
What did you mean? And what did you mean by the words? He's treating me like a leper, like I had the plague.
I meant that I felt isolated, ostracized, as though I knew he had liked my work, but he didn't want me around. I was an embarrassment to him, and he didn't want anything to do with me.
Did Diane Nast ever respond orally or in writing to that memorandum as you requested?
No, she did not.
Scott Doe says his worst fears were confirmed a few weeks later when he found a copy of the letter from Dr. John G. Bartlett, the AIDS specialist, in Stephen Asher's office.
I was angry, and it was like my heart dropped. I felt like, oh my God, this is what it's all about. I know now that what my fear was reality. Even though I try not to let anybody know that I was HIV positive, the explanation for the behavior now was clear.
Scott Doe says it was this discovery that led him to contact an attorney, despite what he says were threats from Pat Petrovic, the firm administrator.
She told me in January, and she told me again in February and March, to the effect that if I brought a lawsuit against the Kohn firm, that I would be blackballed in the Philadelphia legal community by Diane Nast and Harold Kohn.
Scott Doe prepared a 41-page document chronicling what had happened. He sent it to lawyers and to the media.
To 4 news sources. I believe it was ABC, CBS, PBS, The Frontline, and NBC.
Scott, why'd you do that?
I did it because I wanted to expose the law firm for what they were doing.
Why?
Because it was wrong.
Were you mad?
I was angry, yes.
By early March, Scott Doe admits he was using his office to prepare his lawsuit. But he was totally unprepared for what happened when he arrived at work on March 12th.
When I got back to my office, Harold Kohn was standing there. And he said, Pat Petrovic told me that you would not leave the law firm. I want your building pass and your key. If you don't turn it over, I will get security. And I was crying pretty much. I was really upset because, you know, I'm HIV positive, being thrown out of the law firm. I didn't know if I could have any health care medical benefits anymore. I had no prospect for a job. I thought I was going to be blackballed like I was told. I stared at this big bronze plaque that was on the wall that read Kohn Graph. I just stood there and cried for a little bit.
After 3 days on the stand, Scott Doe appears to be an articulate and sympathetic young man. Next, the law firm gets its first chance to attack the plaintiff's story.
John Doe's contract was not renewed for one reason, and one reason only. Because for a period of 18 months, he had not performed up to his capabilities and the expectations of this law firm.
Donald Sweeney is defending the law firm founded by Harold Kohn, one of the nation's most respected attorneys, now accused of breaking the law. On cross-examination, Sweeney's goal is to undermine Scott Doe's credibility and to show that the plaintiff didn't work quite as hard as he says he did.
You have your timesheets up there, sir?
Yes.
Could you get them out, please? Do you have any time for 9/21/91, sir?
No, there is no time for that.
Is that a Saturday, sir?
Well, I should correct that. As I explained before, that sometimes time that was worked on a weekend was charged to time during a week, or vice versa, or whatever like that.
Is it your explanation to this jury that the reason that there's no time on Saturday the 21st or Sunday the 22nd is because it was charged to during the week when you were in the office?
No. There were also times because I was a new associate, was working so hard that I did not want to bill all that time because I wanted to impress the firm on the quality of my work using such a limited amount of hours.
Sweeney asks Scott Doe to turn to the 41-page document he prepared when he first sought legal advice.
Did you, in this chronology where you outline the praise and other material that Mr. Asher gave you over the course of your employment with the firm, include that meeting of November 5th and all of those good things that you claim Mr. Asher said to you?
No, it does not.
Then, in defiance of a pretrial directive by Judge Robert Gothrop, Sweeney raises the issue of sexual preference. He asks Scott Doe about a firm employee who is openly gay.
Did Mr. Dillon tell you that Mr. Kohn had always treated him with dignity and respect?
No, sir. Mr. Dillon's a file clerk. We didn't speak about these terms. About seeing Mr. Kohn.
Mr. Dillon is openly gay.
Your Honor, I'm going to object to this line of questioning.
You thought that over a little bit before you asked the question, didn't you?
No, I didn't, sir.
If you did, sir, I suggest to you that that was reckless on your part.
It was foolish, sir.
That too?
Your Honor, it wasn't foolish. It was calculated and deliberate.
It was not.
Excuse me, Your Honor.
I'm sorry, Mr. Epstein.
Excuse me. They pronounce his name Epstein, sir. This is an HIV case. It's not a sexual preference discrimination case, is it?
I don't believe so.
You don't believe so? Is there any question in your mind about it?
Scott Doe's lawyer, Alan Epstein, is incensed.
There is no question in my mind that they want to change the focus of this lawsuit to one of discrimination based on a disability, to one of the issue of relevance of somebody's sexual orientation and or preference.
Visibly angry, Judge Gothrop tells the jury to disregard Sweeney's remarks.
That is absolutely irrelevant to this trial. You should dispel that from your minds. It is a red herring. It has nothing to do with this case. let's get back to the issues in the case.
Next, Sweeney suggests that Scott Doe decided to sue after reading a newspaper article about the film Philadelphia.
Mr. Doe, when you read that article, were you shocked and scared?
On October 9th, I got the diagnosis of HIV from Dr. Michael Brackman. I read an article about another lawyer who has HIV, gets fired from his job because of it, and I thought, oh my God, this could happen to me.
Sir, did you get the idea for this lawsuit from that movie?
No, sir.
Sweeney tries to give jurors the impression that 80-year-old Harold Kohn treated Scott Doe fairly and generously, and that Scott Doe thanked him with a lawsuit.
Mr. Doe, do you believe that Mr. Kohn was terrified of AIDS or the HIV virus?
I would hope he wouldn't be, but I've been always surprised every day by the prejudices and discrimination of other people. It never ceases to amaze me.
Mr. Doe, if you believe that Harold Kohn was a person who discriminated against you for that reason, why would he give you an extra year at the firm in 1993 with full salary and benefits?
Mr. Kohn did not. Actually, my contract had renewed on October 1st. They were legally obligated to keep me there. And that's what makes this whole thing so suspicious, that I became infected, learned about it after October 1st. And then the letter came in December. And then 1 week or 2 weeks into January, I was told, find a new job, get out of this firm as soon as possible. And they didn't give me the money and say, here, leave. They just wanted me to leave, and they knew that they were legally obligated to pay me for an entire year.
Thank you, sir. I have no further questions.
You may inquire. Mr. O'Brien?
Defense lawyer William O'Brien takes over. On cross-examination, his questioning is limited. The firm's full story will come out later when the defense presents its case. O'Brien asks about a number of events where Scott Doe's story is diametrically opposed to the law firm's version of what happened.
Sir, he wrote you a memorandum saying the honeymoon's over, these hours are unacceptable. He gave you that memorandum, didn't he, sir?
No.
You know there are people that saw that memorandum, and if Mr. Asher says he wrote that memorandum to you, would you say that he wouldn't be telling the truth?
I would say produce a copy to it, Mr. Asher, if you say you drafted such a memo. I know you're an antitrust lawyer. You keep copies of your documents. Let's see it.
But you wouldn't believe him, is that right?
Of course not.
But we're supposed to believe you.
Firm lawyers say they wanted Scott Doe's key and building pass because he was snooping around the office on weekends, looking for confidential information and trying to cover his tracks.
Did you ever change the building records to cross out your name and sign something else, to change the name of where you were going from Kohn Nast to ARA? Did you ever do that?
No, Mr. O'Brien.
O'Brien wants the jury to believe that Scott Doe is lying and that one motive is revenge.
After you knew that your contract was going to be renewed, I think you told us before that you decided to show them that they were wrong and you were going to really get into high gear and work hard. Is that right?
Yes, sir.
And didn't you...
Harder, I should say, not hard.
Didn't you become angry and say that you were really going to ruin this firm?
No, I did not say that.
You didn't say that?
No.
Scott Doe has already testified that he used firm resources, such as stationery, to prepare his lawsuit. Now, O'Brien says it was unethical to send samples of his work to lawyers and to the media.
And do you know that you can't send out information relating to a client without the client's permission?
That's correct. It has to be a publicly filed document.
Yet you sent this material out without ever getting the client's permission. Isn't that true?
Let me respond to that.
Objection. There's been no indication in this case at any time, and he has produced every single document he sent, that he ever sent anything that wasn't a public document, and Mr. O'Brien knows that.
Scott Doe says that after he became ill and lost weight, he heard firm employees gossiping that he had AIDS.
Did you ever hear any of the lawyers in that firm say anything to you about that at all?
No, they're sophisticated, intelligent people. They certainly aren't going to tell me about their thoughts.
And that's what you believe?
Unfortunately, I know what prejudice and discrimination is like, and people don't verbalize it. They act on it, but they don't verbalize it.
And that's what you think happened in this case?
I know that's what happened, sir.
O'Brien ends his cross-examination of Scott Doe with an accusation about the letter from AIDS specialist Dr. John G. Bartlett.
I found a copy of the letter as I was going through our working documents and the various other papers on the table, the back of his desk, in his office.
And you believed that that letter supports your claim in this case?
I think it's one small shred of evidence that supports my claim.
You put that letter in his office, didn't you?
No, sir.
You put that letter in his office on the day you entered and signed the building log, didn't you?
No, sir.
Has the defense succeeded in portraying Scott Doe as a dishonest employee, scheming to profit from his own bad luck? Next, the law firm story.
This episode of Trial Story.
And today I call on the House of Representatives to get on with the job of passing a law that prohibits discrimination against those with HIV and AIDS. We're in a fight against a disease, not a fight against people.
Congress did pass that law, but was it broken in this case? Epstein calls Scott Doe's former employers to the stand, so he'll have first crack at them, putting them on the defensive as witnesses for the plaintiff. Epstein repeatedly goads Scott Doe's former boss, Stephen Asher, into acting more like a lawyer than a witness, hoping the jury won't like him.
On this page, there are approximately 60 or so, I can't count them, different headings. Excuse me, Mr. Epstein, are you going to argue with me? Or let me testify? No,
Is there a word to please turn to 729?
I was...
didn't ask you to slam the book.
I know, but you have to let me answer my questions. I really find it offensive to come to court and testify and be interrupted by it, okay? Now let me explain. You asked me to read headings.
Asher says he praised Scott Doe's work when possible, which was rare, but generally did not put negative criticism in writing.
Do you have any documentation which you retained a copy of which you retained a copy? Any. In all of those books, or anywhere in this courtroom, or anywhere back in your office now, that says, Scott, I'm disappointed, I don't like the work that you're doing. Do you have any notes whatsoever on the side of papers, on the back side of the draft, any place where you actually said to him that you didn't like the quality of his work?
No.
Stephen Asher says Scott Doe just didn't take the time to do good work.
Is it fair to state that in a normal working day, there are approximately, from 9 to 5, there are approximately 6 to 6.5 billable hours at best?
Not in my office. That was the
So
problem, sir. That was the problem.
I'm asking you, Mr. Asher, from 9 to 5.
So you're talking about a normal working day. That's not a normal working day for an attorney in my office working on an important brief to the Court of Appeals. You don't do that.
Mr. Asher, I'm going to ask you again. Let's take 9 to 5. Please stick with my questions.
I'll stick with them, sir.
When you're sitting in that seat, you're allowed to ask the questions, and if I was sitting in this seat, I'd answer them. So let's try doing that. From 9 to 5, how many hours are there?
8 hours, sir. I told him that the reason that the firm had decided not to renew his contract was because there was feeling of dissatisfaction with the quality of his work, that the directors did not feel that he was progressing in a way so that he would be able to develop into a more senior litigator who could really take responsibility for running cases.
After telling Scott Doe his contract would not be renewed, Asher says they did communicate by memo, but not for the reason given by the plaintiff.
I had the sense, my belief at the time was that he was extremely hostile. He was giving off whatever body language was being conveyed. It was crystal clear to me that after January 13th, he was not talking to me.
On cross-examination, defense lawyer William O'Brien gives Asher the opportunity to tell his version of the breakfast meeting that Scott Doe described so differently.
And you were asked by plaintiff's counsel if you had a breakfast meeting in the ARA building at 8 o'clock in the morning. Do you recall that?
Yes, sir.
You weren't asked what was talked about. Tell us what was talked about.
The night before, we had filed a brief in the wallpaper case. During the week preceding the filing of that brief, I was becoming increasingly upset at what I perceived to be Mr. Doe's work habits. This was an important brief, and I didn't think that he was giving it the attention which was deserved. We filed the brief late that night of November 4th. The brief was due. We had to get it in. We worked late. But I was so upset that night that I didn't want one more minute to go by of the workday without talking to him and telling him what I felt. We met for breakfast, and I told him at that time, this was in November 5th, 1991, I said, this is not working out the way I had envisioned. This firm had given you an absolutely wonderful opportunity to work on the biggest cases against the best law firms in the country, to do significant work. And you weren't taking advantage of this opportunity.
Next, O'Brien asks about the letter Scott Doe received from an AIDS specialist. The letter Scott Doe says he later found in Asher's office, making it clear the firm knew he is HIV positive.
Mr. Asher, at any time did you take this letter from Mr. Doe's desk?
Absolutely not.
Either from on top of the desk or inside the desk?
Absolutely not.
Did you ever search through his desk and take anything out of there?
Absolutely not.
At any time, sir, did you know that he was HIV positive?
No, I did not.
Did he ever tell you that he was HIV positive?
No.
Then Epstein takes a last crack at Asher, who flings it back as an accusation aimed at Scott Doe.
Sir, I'm going to ask you whether or not you, from your personal knowledge, are aware of any violations of any rule of professional conduct. And I'm going to step back and let you look at him and look him in the eye and tell me whether he's violated any rule of professional conduct that governs the practice of law in the Commonwealth of Pennsylvania.
Yes, sir.
Would you please tell the jury what rule of professional conduct he has violated that you know of?
There's a rule of professional conduct called, and I don't recall the exact number, candor before the tribunal, and it requires that an attorney be honest in the representations he makes to the court.
Candor before the tribunal. Honesty in court. Lawyer Stephen Asher accuses lawyer Scott Doe of lying to the jury. Next, did the law firm fire Scott Doe because it feared his illness? Or is a lazy lawyer hoping to capitalize on the jurors' sympathy for his condition?
Now continues.
I believe the firm unjustly terminated my career there. I was told, get out of this law firm. Give me your key.
Scott Doe gave several media interviews, all with his face disguised. The defense says Scott Doe took his fantasy of discrimination to the media to profit from his own misfortune. Scott Doe says he knew the powerful firm might try to ruin his career, but he had to go public to protect his rights.
You were asking them to contact you as to what they'd pay. You were trying to hustle this story to the highest bidder.
No, sir. I was trying to finance my litigation to oppose that very expensive computer system, the psychiatrists you would hire, and the various other types of resources, including the 3 law firms the Kohn firm would marshal against me.
And you're not interested in money, are you, sir?
That would be an unfair statement. I think lawyers are all interested in money, but they have principles when they try to obtain their money.
And you were interested...
Some, anyway.
You were interested in money every time you changed jobs.
It was obviously a factor, but not the factor, sir. The quality of one's life is more important than the quantity of the money they made.
And you were interested in money when you were trying to sell this story?
No, I was trying to find a source of funding. Thank God the United States Equal Employment Opportunity Commission entered into the picture.
So they're paying for this?
They're paying to prosecute the American Disabilities Act against this law firm for what they did.
And you were not?
I could not afford it. Justice is expensive, Mr. O'Brien.
Scott Doe couldn't afford a lawyer and fought this case himself until the EEOC and finally Alan Epstein agreed to help. The law firm hoped the case would never get to court and asked Judge Robert Gothrop to throw it out, arguing that laws that protect disabled employees don't apply to people who are HIV positive. But the judge made legal history when he ruled before trial that Scott Doe is disabled because he cannot father a child without endangering a sexual partner.
Please state your name for the record.
My name is Jean Robleski.
Everyone has a right to seek legal advice without recrimination. But when Alan Epstein questions firm lawyer Jean Robleski, she says Scott Doe went too far when he used firm resources to contact lawyers and the media.
It is the firm that owns the stationery, that owns the space in which he operated, that owns the equipment which he used, and the staff which was provided for him. And anyone who uses such equipment or papers to their own advantage for their own business purposes to the detriment of the firm violates firm policy.
Robleski also expressed concern that the advanced law courses Scott Doe was taking in Washington, D.C. were cutting into his time at the office.
And I know about the rigors of graduate work. And when he told me he was taking a course at Georgetown, which is 2 hours away, coupled with the knowledge of what graduate work involves, I had concern that he would be able to handle all of this.
Next, another firm lawyer, Martin Durso, tells of his experience working on an important case with Scott Doe.
I was disappointed, and I was also annoyed because there's a fair amount of pressure involved in putting these briefs together. As I'm trying to make clear, this was a large effort. This was a very large commitment on behalf of our firm. In addition to having to draft the section that he was supposed to draft, I had to draft my own sections. My problem with the plaintiff's work, my primary problem, was that he would show up late for the depositions.
Diane Nast had testified earlier about a meeting to discuss Scott Doe that Stephen Asher allegedly had with the firm board of directors.
Was there anything at all said about HIV?
Nothing.
Was there anything at all said about the plaintiff's medical condition?
His medical condition, it wasn't discussed, it wasn't even considered.
And was the decision of the board not to renew the contract based on anything other than his performance?
No, it was not.
Lawyers from Kohn, Nast, and Graff have told their story in bits and pieces, called to testify as witnesses for Scott Doe. But the jury has yet to hear their full story.
Your morning shower.
Court is now in session. Please be seated.
Good morning, ladies and gentlemen. Nice to see you again.
After 3 weeks of trial and a long weekend of negotiations, a surprise.
But as I understand it, Mr. Doe, there has been an agreement reached. Is that correct, sir?
Yes,
Scott Doe and the law firm of Kohn, Nast, and Graff have settled the lawsuit behind closed doors.
Are you satisfied with it, sir?
Yes.
Is the defense satisfied with it as well?
Yes, sir.
And your clients have had ample opportunity to review it, and et cetera?
Yes, sir.
Correct. Very well. Can we have the jury, please?
Judge Gothrop credits the 12 jurors with the settlement.
Because the lawyers have had the opportunity before you to test their case under the crucible of cross-examination and to see how the facts fell into place, they have been given a vantage point of this case which has enabled them to resolve the matter amicably. The case has been settled.
The judge says the case has put a human face on the terrible disease of AIDS.
It's driven home to all of us the tragedy of this disease, and I know I speak for everybody in this courtroom that we wish him a long and healthy and fruitful life, and one which has much meaning for him. Perhaps this is part of that.
The terms of the settlement are secret. In court, Scott Doe is overcome with emotion. But at a party to thank those who worked on this case, Scott Doe and his lawyers are beaming. And lawyers for the Kohn firm say they just want to get the whole thing behind them. They haven't spoken to the press and declined to be interviewed by Court TV.
I think the case settled for a number of reasons. They thought they were going to pack that jury with homophobic, AIDS-phobic people who would want to not give me any type of damage award. They also, I believe they underestimated the people who sat in their jury, their willingness to learn about the AIDS disease.
There's no room in the world for discrimination, although it goes on. People need to realize that people are people, and whatever disease they have, and as long as they function and do what they're supposed to do, then what's the problem?
After the case settled, the jurors spoke to Judge Gothrop.
A number of them said to me that they were relieved because they weren't sure which way they were going to go.
As the witnesses were called by the plaintiff's side for the law firm, I did notice that their answers were guarded, and I think I could understand that because many of them were still employed there. As far as Scott is concerned, I believe that Scott is a very decent person. I had utmost respect for him.
I thought that he was someone to look up to for that because he continued with his life, whereas some people would give up. I kind of was leaning toward Scott, to be honest with you, with the information which I received. And I know I didn't get all the information, but I was leaning towards him towards the end.
No matter what the jury was thinking, many lawyers were not surprised at the outcome. No one in Scott Doe's situation can afford to wait, perhaps years, for an appeal.
I thought time might be of the essence, and that I thought this plaintiff seemed to have the makings of a terminal disease, and I wanted very much to get it on as fast a track as I could.
The judge says this case could have gone all the way to the Supreme Court because his ruling before trial was the first to say that people who are HIV positive are disabled, even when they don't have AIDS.
I wrestled with it long and hard. We researched everything we could, and it's one of those cases that I just gave a great deal of thought to. A lot of cases you think about every case, but every once in a while you get one you really have to mull over. And
once the trial was underway, though, the question for the jury was simple.
The issue in this case was not so much with the underlying disability and all of that, but basically the purely legal question, factual legal question of how good a lawyer he was.
Did the lawyers of Kohn, Nast, and Graff discriminate against a rising star, or did they have good reason to let Scott Doe go? Now the answer is anyone's guess. Juror Eileen Agger, for one, says the case did change her view of lawyers.
I guess I see them more human. They're just human, you know, they're human. They're just like anybody else, that's all.
Both Judge Gothrop and Scott Doe say they haven't seen the movie Philadelphia. The judge, to avoid any influence it might have had in this real-life case. Scott Doe because it would be too painful. But at least one juror, Dora Reed, says seeing the film made no difference to her.
He's just a human being to me. You know, the movie is one thing, reality is another.
I think the settlement was sufficient enough in magnitude for me to feel satisfied that this firm was punished for what they had done. I'm looking forward, hopefully, to having a long and happy and prosperous future as a lawyer in Philadelphia.